In this video, we'll answer the question whether the sentencing court can assume that the drugs in question were actual methamphetamine as opposed to a mixture when there were no drug seizures involved. The case is United States versus Houston. Donald Houston pleaded guilty to manufacture, attempt to manufacture, and aiding and abetting to the manufacture of 5 or more grams of actual methamphetamine. In order to understand Houston's appeal, we need to recognize that in federal court, the sentencing judge will first look at the sentencing guidelines. It's a book that's published every year by the Sentencing Commission and it lists every crime. These guidelines are no longer mandatory, they're only advisory. So the judge will look at the sentencing guidelines as a starting point. But at the end of the day, the judge can sentence you to a sentence that's higher or lower than whatever is written in the sentencing guidelines. For drug cases, we're going to be looking at section 2D 1.1. And in order to calculate the guidelines, the starting point is to look at the quantities of drugs. In the same section, we're going to have lists of narcotics and weights. And based on that weight, we're going to look at the offense level. That's going to be the starting point. For example, 90 kilograms or more of heroin is level 38. 30 to 90 kilograms of heroin is level 36, and so on. So we'll look at that table and try to figure out where you are on the offense levels. Now, for certain drugs like PCP and methamphetamine, we're giving two alternatives. It could be a mixture or it could be pure. Now, the sentencing guidelines tell us to recognize that there's two alternatives, and based on the weight, it's going to be different offense levels. For example, 45 kilograms of methamphetamine is level 38, but only 4.5 kilograms of actual methamphetamine, meaning pure methamphetamine, is level 38. So there is a 10 factor between the actual versus a mixture, which makes a huge difference in some of the cases, including Mr. Houston's case. In Mr. Houston's case, the difference between an actual and a mixture of methamphetamine makes a huge difference on his base offense level. Now, in the sentencing guidelines, we're going to have a table here at the back of the book, that lists the offense levels on the left side and criminal history category on top. Where they intersect, we're going to have months. It's going to be ranges. Now, I already have a video, I'll link it here above, that calculates how to figure out your criminal history category. Now, if somebody has no criminal history, or if they have only one criminal history point, they're going to be in category 1. And for example, in Mr. Houston's case, if we assume that he has no criminal history, then if we're talking base offense level of actual methamphetamine, he's going to be at level 34, 151 to 188 months. Now, if we're talking about a mixture, then he drops all the way to level 26, which is 63 to 78 months. That's a huge difference. That's more than double between a mixture and an actual methamphetamine. The government bears the burden of proving the quantity and quality of the drugs. Now, in the cases where the government seizes narcotics, they're going to do a lab report, and at the end we're going to know the purity. But what happens in the cases where there is no seizure? For example, if the person is a middleman, or if there's a manufacturer, there's a number of transactions, and not all of them were seized. Here's what's going to happen. If we have some seizures, then the government will attribute the purity of those seizures to the quality of the drugs that were not seized. But what happens if there's no seizures at all? For example, when there's a manufacturer and we know that the drugs were manufactured in the house, but at the end they were not seized. The government will use testimony of the defendant, of other co-defendants, or maybe an expert to try to prove the purity of the drugs. Before Mr. Houston was sentenced, a probation officer came out and interviewed him. Now, in all of my federal cases, probation comes out and interviews my clients before sentencing. They try to get more information about my client, their background, their employment history, their medical history, about the case itself, the criminal history, and so on. These reports are rather important for the judge to get a full picture before my client goes before him for sentencing. Now, in this case, the probation officer attributed these confessions and said that Mr. Houston confessed to actual methamphetamine. The sentencing judge agreed with the probation officer and said that these confessions do in fact look like Mr. Houston confessed to manufacture of methamphetamine, and we know the quantities of the drugs. And because he believed that this was actual methamphetamine, he sentences Mr. Houston to a higher level. The appellate court says that it was a mistake for the probation officer and the judge to assume that we were talking about actual methamphetamine. When we ask a layperson like Houston the amounts of drugs that he was cooking, it is rare for a person to speak about actual methamphetamine. He's most likely talking about, in general terms, the quantity of the drugs, not the components or the purity of the drugs. This case proves once again that it's important to have a good attorney on your side, even if you're not going to trial. Because for Mr. Houston, the difference between a mixture and actual methamphetamine is years in prison. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.